Now call case number 128210. Are you ready, Ms. Harper?
May it please the court, Gail Larkin, Disciplinary Administrator, appearing on behalf of the Office of the Disciplinary Administrator. Chief Justice Lucard, I would request 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you. This is an original action in discipline filed by the Disciplinary Administrator's Office against Laine Rundus. The court admitted Mr. Rundus to the practice of law in 2007. On April 3rd of this year, the court entered an order temporarily suspending his license following a felony conviction. His license remains suspended at this time. On August 23rd, 2024, the Disciplinary Administrator's Office filed a formal complaint against the respondent alleging violations of KRPC 8.4 and Supreme Court Rule 219. September 18th, the parties entered into a summary submission agreement, which details the agreed upon facts, rule violations, recommendation for discipline, as well as the consideration of the ABA standards. On December 5th, by permission of the court, the parties amended the summary submission agreement to include facts and evidence regarding the respondent's compliance with the terms of his Republic County probation that he remains on today. In the summary submission agreement and the amended agreement, the parties jointly recommended that the respondent be suspended for 1 year and that prior to reinstatement, he undergo a hearing to consider the reinstatement of his license to practice law. The facts in this case are straightforward and agreed upon by the parties. Between March 3rd, 2023 and June 30th, 2023, a period of 4 months. Took me a long time to calculate that. Not good. That's why I don't do math. The respondent was arrested 3 times for driving under the influence of alcohol. The respondent went unrepresented in all 3 cases, and all 3 cases resulted in a conviction based upon the respondent's plea. Third conviction is a felony conviction for which the respondent remains on probation. I want to talk a little bit about what Mr. Rundus has done since that third conviction. He has completed the alcohol treatment required by the probation order. He participated in outpatient treatment for 13 months. Originally, it was intense outpatient treatment, and I think that lasted about a year, and then or a good 6 months, and then for the remaining time, it was stepped down to continuing to be outpatient, but not the intense level that it had been. On October 7th of this year, he was released from treatment. And further, it's important to note that the last time he consumed alcohol was the night of his 3rd arrest. He has not consumed any alcohol.
I'm sorry, you trailed off there when you were
sorry.
getting to the date.
The night of his 3rd arrest, which is June 30th, 2023. It's been nearly 18 months. The respondent has complied with all provisions of the probation order, and if he's able to complete the remaining hours of community service work by February 5th, he and his probation officer expect that he would be released from probation a year early. The Rule 223 adopted by this court in 2021 allows the disciplinary administrator and a respondent to enter into an agreement regarding the facts, the rule violations, and a mutual recommendation for discipline. Summary submission serves two important purposes. It allows respondents to take responsibility for their actions, and it also allows that disciplinary cases proceed through the system sooner rather than later. I recognize that summary submission is not appropriate in every disciplinary case. It's appropriate to consider an agreement like this in those rare occasions where both parties, the disciplinary administrator and the respondent, agree to all the facts, all the rule violations, and the recommendation for discipline. This is one of those rare disciplinary cases where summary submission is a perfect fit. The parties agreed to all of the facts of the 2 rule violations and the recommendation for discipline. The facts in the amended summary submission agreement and the original summary submission agreement are nearly identical to the facts in the formal complaint, with some added information recently about the respondent's compliance. Under Rule 223F, the Supreme Court is not bound by the rule violations that the court finds, nor is the court bound by the recommended discipline. So I want to address those two areas in a little bit more detail. In the summary submission agreement and the amended agreement, the respondent admitted that he violated KRPC 8.4B for engaging in criminal conduct that adversely reflects on his fitness to practice. And he stipulated that he failed to report those charges and convictions as required by Rule 219. There are no other rule violations asserted, and those are both clearly established by the facts contained in the summary submission agreement. So then the next step is to discuss the recommendation for discipline. And in the summary submission agreement, we went through the ABA analysis, looked at the duties violated, the mental state or the level of intent of the respondent, and the injury or potential injury that was suffered. In this case, the respondent knowingly violated his duty to the public and to the profession by committing criminal acts. As a result of the respondent's misconduct, he caused potential harm to the public and to the legal profession. Luckily, no actual harm to the public occurred in these three DUIs. Based upon the duties he violated, the level of intent, and the potential for injury, the respondent and the disciplinary administrator's office agreed that standards 5.12 and 7.2 apply. Both of those standards indicate the presumption is suspension. Consideration of aggravation and mitigation can change that depending upon how compelling the evidence is on both regards. Parties agreed that there was a pattern of misconduct, substantial experience in the practice of law, and illegal conduct as the aggravating factors in this case. The parties also agreed that the absence of a prior disciplinary record, the absence of dishonest or selfish motive, the personal and emotional problems experienced by the respondent during this time, and the imposition of other penalties or sanctions are the official mitigating factors that are present, and those were all included in the summary submission agreement. In addition to those standard factors, there's a couple of additional, I think, mitigating or pieces of evidence that were presented that are also mitigate the misconduct in this case. Number one, he has not consumed any alcohol since his third arrest. He's done very well on probation. He completed the alcohol treatment, and he is on course to be released from probation a year early. Of course, there's no client harm in this case. This is a case that occurred outside the practice of law. And the fact that there is no client harm also, I think, is a mitigating factor. I think that the mitigation outweighs the aggravation in this case. So while it's, I think it remains in the realm of suspension, but it's not it's not so compelling that it would kind of result in a lesser sanction. But I think it supports a shorter suspension as compared to other similarly situated disciplinary cases.
You may have just answered one question I had. It looked like looking at some of our similar cases where there are 3 or around that area of DUI convictions, suspension's been typically a 2-year suspension.
Right.
And I'm hearing that maybe it's the aggravating or the mitigating circumstances here that moves you off of that. But I guess my question is, for consistency, does a longer suspension make sense with, and why no consideration of a stay, I guess? Is it just because it's the 1 year and that's the appropriate length given those mitigating circumstances? I'm just trying to see how it fits in with some of our other cases like In re Cure, Davis, Hardy, and Hubin.
Certainly. I mean, I think if you look at Hubin in particular, and perhaps the Davis one that was decided earlier this year, those both, the net result was, in the Hubin case, no suspension other than the temporary suspension that she experienced after the conviction before the disciplinary case was resolved. And in Mr. Davis's case, the same thing, but with that additional 6 months. And so those were certainly shorter periods of time, given the
Stays.
given the stays and given the I guess the bottom line. But if you look at some of the other cases that didn't have those stays and those things, 2 years is pretty universal. I looked at 8 different cases. And, you know, there was a 2-year suspension in Davis. After 6 months, he received probation. The suspension was not made retroactive to the date of his temporary suspension. In the Cure case, there was an 18-month suspension. It was made retroactive to the temporary suspension, but he also was required to have a reinstatement hearing. So when you have the different factors, the retroactive and the reinstatement hearing, that really impacts the length of the suspension. And in this case, I think that a 1-year suspension is appropriate, even though it looks like 1, 2, 3, 4 of the cases I looked at had 2-year suspensions with certain modifications. 3 of the cases had indefinite suspensions. And I want to address 2 of the cases that had indefinite suspensions. The Meyer case from 2015, Mr. Meyer had been convicted of DUI on 7 occasions. And I think that just takes it outside the comparison in this case. In the O'Neill case, which is the other indefinite suspension case, that had kind of additional information, it was from 2007, and he had been convicted of his 3rd DUI after being admitted, but he had been convicted prior to being admitted and had lied on his bar application. And there was additional misconduct that was involved. There was certainly a lack of taking responsibility for his actions and that kind of thing. So again, I don't think that one, I think that's kind of off the radar as well. The only one that's a little bit, maybe would require a little bit more explanation is that Laskowski decision from 2006. It was also an indefinite suspension, and that was made retroactive to the temporary suspension. But I think that given the circumstances in this particular case, the significant mitigating factors, I think that a 1-year suspension with the requirement of a reinstatement hearing extends that suspension because of the process it takes to do the reinstatement. Typically, it's about 9 months, and so it adds that time.
The effective date you want the suspension for your recommendation is the date of the opinion or retroactive or?
You took the words right out of my mouth. Because he's done so well on probation, I believe he deserves to have, and maybe deserves is not the right word, but I believe it's appropriate for the suspension to be made retroactive to the date of his temporary suspension. And I make that recommendation, even though it's not in the summary submission agreement, because of what he has done since we entered the summary submission agreement. He's taken a lot of steps, and there's a couple of cases I wanted to,
Can
Well,
I ask,
go ahead.
just while we're on that, how does that fit with the recommendation that he be released from probation? That one of the things he showed at his 229 hearing is, or I'm sorry, that's what it's gonna be for me for a long time.
232.
232
Yes,
hearing,
I know.
is that he had, been released from his criminal probation.
Correct.
So give me the timeline of how that all
Fits
you know,
together?
Yeah, fits.
Certainly.
I mean, especially because I understand the dates that there's a hope he will be released a year early from
Certainly.
that. What happens if that doesn't occur?
Well, if the recommendation is made retroactive to the date of temporary suspension, which is April 3rd, then he would be eligible to apply for reinstatement April 3rd, 2025. But I think this court should include requirements that have to exist before he can apply for reinstatement. So number one, that he has satisfied obviously the standard language of any orders in the court's opinion, but as well show that he has been released from his criminal probation before he's allowed to apply for reinstatement. So if he doesn't get the community service work hours done by February 5th and he remains on probation for a longer period of time, that would impact when he should be able to apply for reinstatement. That should be a condition precedent. But I think that, one of the things that I saw a little line in, I think it was the Cuban case, and I think that the circumstances, the Davis case, were kind of consistent. And it said that in the Cuban case, the respondent has made concerted and consistent efforts to address the root cause of the misconduct that gave rise to the disciplinary case. And I think that's present in this case, and that's why I think he should be given the benefit of the doubt and be allowed to apply for reinstatement sooner rather than later. I think that encourages that level of cooperation and interest in maintaining his sobriety and receiving the treatment that he needs to receive going forward.
The outpatient treatment you referenced then apparently addresses both underlying systemic problems, perhaps with depression or at least episodic problems with depression, as well as the alcoholism, or how does that? Or is it a dual diagnose? I don't know what the specifics are of the diagnosis or the treatment.
I don't know that I'm equipped to answer that question. I think that maybe Mr. Rundus might be in a better position to. I did note in the discharge summary that they didn't recommend any additional treatment, any treatment for depression. However, in my conversations with Mr. Rundus, I believe that that is an ongoing issue that he needs to address before he should be reinstated. And so that would be something that I would, at the reinstatement hearing, want to see that he has obtained sufficient treatment to address his depression. But in the discharge summary, it specifically didn't refer him or the discharge plan for additional treatment. Any other questions? I see I'm out of time. I apologize for going over.
I have a couple questions. I did see in that they do recommend he, let's see. I can't remember, it's in volume 2. Okay, challenging, blah, blah. The counselor does believe that when Laine is ready, he would benefit from mental health services to address his ongoing depression, but also understands that during, I guess, the year that he'd been there, that he had not found a mental health practitioner he is satisfied with.
In the plan going forward, there wasn't any specific like referral or whatever. And that's what I'm talking about. I think that once he gets to the point where he's ready to do that, that all has to have happened before the reinstatement hearing. So he can prove that he is in a place where he can handle the practice of law.
Okay, so do you know whether or not, and I guess I could ask him when he comes up, but it seems like a really big issue as I'm going through this is his lack of health insurance. Do you know whether he has health insurance now?
I do not.
Second of all, he's been great in complying and you know, for a whole year, and was released on October 7th. And he's been clean, and I'm assuming that they have him drop UAs, but he's also was dropping and is dropping UAs on his criminal probation, which if he comes off of that, which it looks like might be February 6th, 2025, what will the incentive be for him to not drink? I mean, right now, his probation would be revoked and he would have to serve an underlying sentence.
You know, in reading the discharge summary and the discharge plan, I noted some of the statements that Mr. Rundus made about the benefits that he has received physically and personally by not drinking, and that, you know, he has no intention of resuming that because of his recognition of where it took him and how much better he is feeling and doing without drinking.
So his diagnosis at admission and at discharge on October 7th is alcohol use disorder severe. So I understand what you're saying about the desire
Certainly.
to, you know, that he feels so much better, but
I do.
as of February 6th, 2025, he will have no accountability at all, and he might even be without health insurance. But maybe these are better questions for him.
I certainly think that a KLAP monitoring agreement at the time he comes back to the practice of law would be in order, perhaps, you know, some sort of probation. But in my discussions with Mr. Rundus, it sounds to me like it will be some time before he applies for reinstatement because he wants to be able to take care of some of these personal items. And he can certainly address that better than I, but that's definitely been our discussions, that he, you know.
But I thought you said that if you count it retroactively, his suspension, that he would be eligible April 3rd, 2025. So he's said to you that he doesn't plan to seek reinstatement in April of 2025?
Absolutely. I've made the recommendation because I think that his hard work deserves that recognition. But my understanding is he will not be applying for reinstatement until he feels that he is ready and he's been able to take care of and get his depression under control and has the proper tools in place to be successful. But my recommendation, and I kind of sprung it on him this morning. I didn't tell him I was going to recommend that until today, but I've been very impressed with the strides that he's made and the concerted effort he's made to really turn his life around. I mean, he had 4 really bad months in 2023. And it was really kind of this isolated period of time. And I think that by giving him kind of that light at the end of the tunnel, knowing that he can apply for reinstatement whenever he feels ready, I think that that would be an incentive for him to continue to work his program and to seek the assistance that he needs.
Thank you.
There's no other questions? Thank you.
Mr. Rundus?
Laine Rundus, pro se, and may it please the court. Thank you to the court for this opportunity. I'd also like to thank the disciplinary administrator's office for their professionalism, their diligence, and quite frankly, their consideration for not only the rule and practice of law, but for me as a violator. So I failed. I failed the profession, the rules of professional conduct, my family, and my community. I failed my own conception of my character, my values, and the very simple notion that I was a decent person. The only solace I take in my actions was that I was not practicing law at the time of my at the time of those actions. I understand that I do not deserve really to keep my license. I also know that I am not well enough to practice law. And to address Justice Standard's question earlier, I have no intention of practicing law in the near or distant future.
You know, I didn't understand from the record, I probably missed it, that you weren't actively practicing law
I haven't
in the
actively,
spring of 20, I'm sorry, go ahead.
I apologize, ma'am. I did
That's
not.
okay.
I haven't actively practiced law since August of 2021.
Okay. Thank you.
I have helped. I moved back to Munden, Kansas. And so when the local farm boy lawyer comes home, the neighbors start calling with questions. And so I answered some questions, but I never held out a shingle or held myself out as a lawyer. It was just family friends that had questions about a wind lease or something along those lines, but I never took payment. I never advertised myself as a lawyer. It was basically just family friends that would corner me at the coffee shop or something like that. So, but no, I understand that I self-medicated my depression with alcohol. I have had a flitting relationship with health insurance. To a certain extent, it was I've pursued it and then not pursued it, and then the concept of putting gas in a car you've already wrecked was kind of a reason against pursuing health insurance as vigorously as I could have or should have. I've maintained efforts to secure mental health. Prior to all of this, I sought mental health treatment prior to April of 2022, and I continue to pursue and receive mental health treatment today.
What are you doing along those lines? It appeared from Ms. Larkin's presentation that you completed your alcohol treatment, but is there anything ongoing at this point?
Yes, I continue to pursue mental health treatment through an online service at the moment.
And how, tell me, just so you don't have to go into great detail, but what do you
Once
do?
a month.
Okay.
And ARC to address the other previous questions, the facility that I received my intensive outpatient treatment at was geared more towards drug and alcohol abuse specifically, and less so about mental health. Although mental health, as I'm sure this body understands, is that mental health and criminality, which was where most of those folks came from, go hand in hand in many instances. So the nature of the substance used to self-medicate in this instance was pretty universal. And so although it was primarily alcohol treatment, I was there because of DUIs, that's what they treated me for, was alcoholism. But I think my primary issue is mental health, less addiction. So I'd stand for any questions.
Again, kind of more of a just what happened with your criminal cases. You've had 3 DUIs.
Yes.
And it looks like it only resulted, how much jail time did you do?
I spent 48 hours with the first DUI. The second DUI took place in Nebraska. So I had a 30-day sentence in Nebraska. And then my felony DUI, I think, resulted in 5 days of incarceration and then an underlying sentence after that.
And the underlying sentence didn't include a mandatory 90-day jail for the felony?
No.
And what is the, I know that we've talked about a possible early discharge from probation, but what would be the full term of your probation from?
I believe it's 2 years from February. So it'd be February of 2026, I believe, would be the full term. But I don't have that information at the ready, and that's my best guess, Your Honor, Your Justice.
And having to spend some time in Mahaska, around Munden and up into Hubble, Nebraska, are services, access to services an issue currently for you?
The city of Belleville does not have a city attorney and hasn't had one for a few months. There is one practicing attorney that lives in Scandia, but that's the only, to the best of my knowledge, that's the only attorney that lives in Republic County.
I meant more for your own mental health or any other services that you might feel that you need moving forward
I use it online.
online. And that's been enough.
I do not drive at the moment as well. So
Yep.
that's another compounding issue.
Is it the same person every month or is it a different person every month?
It could be the same person every month, and it has been the same person several times, but sometimes schedules don't align, and so it's hard to. Continuity has been an issue.
And thank you for, your driving privileges are currently suspended, or you're doing that by choice? What's your status with that?
I pursuant to the present law, I have a 3-year suspended license. I was eligible to have a reinstatement, have it reinstated in with the interlock device. I have chosen not to do that at the moment because it sounds silly, but there's a penance to pay for my actions. And I know it's inconvenient for those that are tasked with ferrying me here today, but I'm a felon, and it shouldn't be easy to be a felon. No other questions?
Questions? Thank you.
Justice Rosen, I would like to clarify that after he was released from the 5 days of jail on the felony conviction, he did serve a term of house arrest. It was only 30 days. It was not 90 days. That's Exhibit 8 on page 75 as a journal entry.
Yeah, the law must have been amended from what I was familiar with, because it used to be on a third and subsequent mandatory 90 days up to a year, and that was pretty strict. So I guess it's been relaxed. So
I don't think it has. I don't think it has. I actually did some research on a different case, and I think that it's the same as you and I recall from some time ago. So I'm not sure. I'm not sure how that happened, but I would stand for any additional questions. I would waive my time. Thank you.
Thank you. Thank you to both counsel for your arguments this morning. The court will take this matter under advisement.